Good evening. Welcome everyone to Thursday, December 18th, 2025 Board of Adjustment meeting. Before we get started here, we're going to have Mr. Jenkins brighten our evenings here with a little bit of holiday spirit.
By a choir and folks dressed up like Eskimos. Everybody knows a turkey and some mistletoe help to make the season right. Tiny tots with their eyes all aglow will find it hard to sleep tonight. Do you know Santa's on his way? He's loaded lots of toys and goodies on his sleigh. And every mother's child is going to spy to see if reindeers really know how to fly. And so I'm offering this simple phrase to kids from 1 to 92. Although it's been said many times and many ways, Merry Christmas, Merry Christmas to you.
Thank you, Mr. Jenkins, and happy holidays to everyone. Go ahead and get started here. Call roll, please.
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Miss Denny?
Here.
Mr. Jenkins?
Here.
Miss Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That's 6 present.
Thank you. With 6 present, we have a quorum. Introduction of staff, please.
Yes, sir. Good evening, everyone. My name is Jamie Fensky. I'll preside as the hearing officer for tonight's meeting. To my left, we have Mr. Mark Kennedy, our IT staff for the evening. And to the far right, we have Fred Townsend, our legal counsel for the evening.
Thank you. At this time, everyone, please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
Yes, sir. The applicant for application A-25-32, Jesse and Nancy Miles, has asked to be removed from the agenda. They would no longer like to move forward with their variance request.
Thank you. And we have an old business item on our agenda tonight, the Brennan property.
Yes, so this is going to be application A-25-25 for Donna Kay and Jeffrey Scott Brennan Sr. And I'm going to ask Mr. Townsend to help us with that one.
Thank you. So I believe it was 2 months ago, this board heard an application that was originally submitted by the applicant without benefit of counsel, in which the applicant asked for the Board of Adjustment to determine that they were in fact a farm. And during the course of that public hearing and business meeting that followed 2 months ago, it became apparent that the applicant, with the benefit of counsel, was arguing instead that they were not, or they agreed that they were not a farm, but that for other reasons they should be permitted to have more than 5 animals on their property. That that remaining question was not decided 2 months ago, and consequently, both the county and its legal representative and Mr. Pardee, representing the Brennans, concluded that it would be best, most efficient, and logical for us to stipulate to reconvene and reconsider the application with a focus on the remaining issues that weren't decided. And since then, you've received submissions from both applicants in writing. There are some ground rules that have been agreed to that we're going to try and adhere to the best we can. And tonight is the business meeting in which you're called upon to decide the outstanding issues which were addressed in those submissions. So procedurally, are there any questions for me at this point as to why we're here? And if not, I'll turn it back over to our chairman. If at a point later on during deliberations you have questions that you wish to put to me or to staff, of course you're invited to do that as always.
Great, and there's no public testimony tonight, correct?
No, it's been agreed that there's no need to reopen the public hearing, so there won't be, it wasn't published as a continued public hearing, and we won't be hearing from the public on that.
Very good. And we will have one recused, Mr. Jenkins. He was not here on the October meeting, so he will be recusing himself for this vote. So with that, I'll open it up to the board for discussion.
I think the question is whether or not the provision in 20534 applies here. 20534B, no more than 5 such animals shall be permitted on a residential lot. Applicant is putting forth that this would not pertain to this property. The way I read it, using looking at permitted uses and use regulations, there it says, except as otherwise provided, there may not be more than one principal use or principal structure on a lot, except for lots with split zoning, which I don't believe this is, in which case there shall not be more than one principal use or principal structure for zoning classification. So it would follow to me that since the primary use of the lot is residential, it is a residential lot, and that this restriction does apply in this situation.
Yeah, good point. So I mean, just looking over the applicant's reason was the AC zoned. So he's fighting for that the AC zone property, that he could use the agriculture, the animal production under that. But yeah, then the county is applying that, what you stated, the residential lot. So that's what's at stake tonight. What we need to decide on whether 5 animals will permitted on this lot or not. Any other discussion or a motion?
So, Mr. Gallo, um, are you of the opinion that this property is, that the county is authorized to come to the conclusion that this is a property not devoted to an agricultural use, but instead subject to a residential classification?
Yes, and it's being used as a residential lot. So I believe that the county can lawfully impose farm animal limits in the AC zone.
Despite the fact that it's an AC zone lot.
Yes, correct. There, permitted use, the phrase that the applicant used was regarding by right that they can be for agriculture and aquaculture, but there's also by right that they can have residential use as well. I think it puts it on the same footing. However, because the primary use and the primary building on the property is residential, that will take precedent. It becomes would be regarded as a residential lot, and therefore that limitation would apply in this situation.
I agree with Mr. Gallo. There's a home there. There has been, and its primary use is residential.
I make a motion that the county may lawfully impose farm animal limits in the AC zone as spelled out by the opinion of the county attorney.
I'll second that motion.
We have a motion and a second.
Thank you. Ms.
So-
Hudson?
So
Oops,
is it
sorry.
implied from the motion that the application is appealing the interpretation of the county staff is to be denied? Or that the county's position is to be upheld? Is that what is meant by the motion?
My intention is to say that the county's position is upheld.
I second that motion as restated.
Thank you. Ms. Hudson?
I vote in favor of the motion based off the testimony that we heard from the county's attorney and all the other testimony that we heard back in October.
Thank you. Mr. Carter?
I vote in favor of the motion based on the testimony presented tonight and the testimony previously.
Thank you. Ms. Denny?
I vote yes. I agree with the county's initial statements with regard to the property.
Thank you. Mr. Gallo?
I vote in favor of my motion based on previous discussion,
Thank you.
testimony we've heard.
Thank you. And Mr. Cusick?
I vote in favor of the motion based on the property's parcel information, which is listed as residential, and then as that property is the physical attributes of that property is residential. And I just think failure to impose this section 205-34 really diminishes the purpose of the code here. Just allowing residential properties to be able to keep poultry with no limitations. I think it's a risk here with obviously with diseases and soil contamination and all that stuff.
Thank you. That's 5 in favor of the motion.
Thank you. With 5 in favor, the motion is approved that the Kent County ruling is upheld. All right, we'll begin the public hearing now. We'll start with the public hearing introduction.
Yes, sir. So again, good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's meeting. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 3 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning tomorrow between 8 a.m. and 5 p.m. at 744-2471. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearings were published on November 28, 2025 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you, Jamie. At this time, we'll have statement by counsel. Mr. Townsend?
Thank you, Mr. Cusick. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for determining area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And it's also here where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board's not permitted to consider factors other than the 4 I've listed, which restated briefly are 1, the nature of the zoning district, 2, characteristics of the area, 3, whether the variance would if granted, would seriously affect neighboring properties, and 4, whether the applicants are confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are directed to exclude from their testimony any discussion of personal disputes or acrimony between the applicant and neighboring property owners. The board is not authorized, obviously, to resolve those disputes. Mr. Cusick, that's my statement.
Thank you, Mr. Townsend. I think at this time we'll begin with application A25-33.
Thank you. So application A25-33 is for Amy and George Lewis. The present zoning district is AR. Proposed variance is a variance from the maximum size of an accessory dwelling unit of 50% of the floor area of the principal dwelling unit to legalize an existing accessory dwelling unit. Present use is residential. Proposed use is same with legalized accessory dwelling unit in the Levy Court District 6 for Mr. Hertz, located on the east side of Iron Mine Road, approximately 880 feet north of Sandtown Road, west of Felton. This is the the existing layout of the existing accessory dwelling unit. The principal dwelling on the property is 1,482 square feet. The permitted ADU would be 741 square feet. And the existing accessory dwelling unit is 1,063 square feet, which would be 71.7%. Here you will see the main dwelling to the left, the 1,482. The proposed, or the existing ADU that we're looking to legalize is there showing in red onto the attached garage, or onto the detached garage that is there, sorry. This is looking at the property from the front. You will see the dwelling here to your left. To the right of that is the detached garage with the ADU behind that. Looking down the road, the other direction. This is the existing detached garage. The gray portion here is the area of the ADU. Looking towards the back of the building of the ADU. This is looking from the side of the detached building up towards the back of the house. Side of the house. And the aerial. I believe we have someone here to speak on behalf of this application. Please come forward, state your name and address, and allow our attorney to swear you in, please.
Good evening. My name is Audrey Ellen Wagaman, and I live at 35727 Tarpon Drive in Lewis, Delaware.
Ms. Wagaman, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Thank you. First point I'd like to make is my clients bought this with the existing property, the existing home, as well as the existing extra building. It all was in place, totally unpermitted. The last realtor that they used did not check on permits, and so I am their realtor now. They live in Florida, and I'm trying desperately to make good on all the things that should have happened when they bought it originally. So the ADU that's in there, they didn't realize the building was already there, so they altered the internal aspect of the building. So they did have an electrical inspection. They did make sure the septic system was brand new and expanded not only to cover the house, but also the ADU. But they did not go through, obviously, this process. So as I got involved and I realized the missing links, we have been trying the last 6 months, starting with retiring the title on the mobile home. We actually redistrict. As I know, impact on the area is important. We did rezone it from being business neighborhood to AR. And so with the BN and the previous owner, who did all this without permits but did have the BN zoning, they had a company that had trucks there, and there was a lot of more traffic, where now with the way they've configured things, it's just a building for a major residence, some kind of a large hobby area with storage for cars, and then the alternate, the ADU, was for their son. So behind the house is land, state land that'll never be developed. Since they did their submission to planning and zoning, they have written a note, and the neighbor has written a note, and I do have pass-outs. Summarizing what Mr. Townsend had said, yes, the planning and zoning initially did say that they would deny the application. Aligning with their denial, I'd like to make the following points. First, the current zoning is AR because the current owners just received approval to change it from BN. The current ADU provides no impact on the neighbors, such as additional traffic or a physical outbuilding that is unattractive, as this building has been there for years. And the owners are requested the AR zoning to return the property to a status that was more conducive to maintaining the rural nature of the area. We've had public notice postings twice now, and each time I've gotten phone calls, and each time when I explain what they're doing, they said, "Oh, that's so much better, thank you." And in your packet, there's actually an email from one of the neighbors. Number two, although the owners now recognize they should have received additional permitting to divide the existing building into the living quarters, there was no change to the existing building, so there was really no change or impact to the area because it's been there for so long from the previous owner. The owners have been working on getting everything done right. We've been working on it for the last 6 months. Our next step will be to just go back and get permitting and getting the electrical inspection and the septic inspection and get the actual permit for the building that was erected by the former owner. I've provided an email from the immediate neighbor and talked about and there's additional neighbors who've talked to me. When I explained to the neighbor that the owner at this time is looking for approval for the improvement that has already been there, they were all more than satisfied. And lastly, although there would not be a drastic additional hardship on the current owners, without the ADU approval, the value of the property would be less. Also, in today's society, I'm a Realtor, what I find is that families are living together, be it your child who doesn't move out even though you wished he had at 18, or when you do take care of your elderly parents, it's really good to have them close by. So we feel that this addition to this property is something that aligns with current society and would be due an exception for those reasons. There is a full email from them, and I know I'm allowed 3 minutes, so I guess I can't read their email, but I would ask that you would, and if you do get a chance to read it before you make a decision, I would be grateful for that.
3 minutes apply to people who...
Yeah, I think we could touch base on this letter, if you would like.
Can I read that?
Yes, ma'am.
You're the best. Keep saying yes. No. You're on a roll. Hang on, let me. Okay. Dear members of, the Adjustment Board, I'm writing to respectfully request approval to the ADU located at my property at 176 Iron Mine. The primary residence on the property is a manufactured home, which is smaller in size than many site-built homes. The proposed ADU is located entirely within an existing outbuilding that is substantially larger than the manufactured home. Importantly, the ADU occupies less than half of the existing outbuilding, and no expansion of the building footprint is proposed. The property consists of approximately 2 acres and directly backs up to state wildlife area, providing significant natural buffering and separation from neighboring properties. Due to the size of the parcel, the surrounding open space, and the absence of nearby residential development, the ADU will have minimal visual or functional impact on the surrounding area. The reason the ADU exceeds 50% of the primary residence is directly related to the modest size of the manufactured home, rather than an intent to overdevelop the property. Despite its relative size, the ADU will remain clearly accessory in use, subordinate to the primary dwelling, and consistent with the character of the property and surrounding area. This proposal makes efficient and responsible use of an existing structure, avoids new construction, and preserves the rural nature of the property. It does not increase the impervious surface, does not require additional land disturbance, and maintains compatibility with the adjacent state game land. The ADU utilizes all existing utilities serving the property. In addition, a new septic system has been designed and installed specifically to serve both the primary residence and the ADU, ensuring adequate capacity, code compliance, and no adverse impact on public health or the environment. No additional utility extensions or infrastructure upgrades are required. Given the unique characteristics of the property, the existing building configuration, and the lack of negative impacts, I respectfully request the board's approval of this ADU. I believe this request represents a reasonable and appropriate application of the zoning regulations under these specific conditions. Thank you for your service to the community and your thoughtful consideration of this request. So we hope, rules are guidelines. So hopefully you can see that since this has existed for years and that it does provide a practical application that's not as invasive as the former BN zoning was on this facility. And again, the former owner is the one that built the big building and had all the trucks there, and we're trying to just make things right. So I thank you for your consideration.
Thank you. Any questions, comments?
I have some questions. Can you tell me the anomaly that the person living in this ADU has that would require them to be living in an ADU?
In this case, they had their son there. He was like 24 years old. So
Is he handicapped in any way that
no,
he needs an ADU?
he was not. They have vacated. They don't live there now. We're looking to sell it, and when we sell it, we want to make sure that everything's done right. I'm not doing this like the last realtor. This is going to be done right.
So certainly, the house could be sold without taking down this, what is it? 1,063 feet of addition, and it could just transition into another room of the house and still fit within our code. And it's really, it truly is the code of the county. It's our law. The reason you have to come here is so that if you have a particular situation that is an impractical difficulty, not something not a self-inflicted wound, but a true practical difficulty, that's one thing. But somebody built something on a property and you can't just say, oh, well, it adds to the value of the property. I mean, you have to follow again, not just the rules, not the regulations, the code.
Right.
And you come before this board because we're protective of it, and we try not to set precedents so that the next guy can come in and say, well, we didn't know, we didn't. And ordinarily, the first thing I would say as I started to speak is, I'm not a fan of the don't ask, apologize way of doing things.
We agree, and they had no idea when they bought this. This all existed. So they were just victims of my peer group not doing their job.
So they did not add that ADU. That was already there when they purchased the
The
property.
entire building was physically there. What they did do is they customized an area of it for their son to live in. but there was no addition to the building at all. The footprint was all there. The last guy started, when I went to the permit department, these people all know me well at this point, and he had taken out a permit but never followed up with it, and yet he built this massive structure, ran his company out of it, and they paid cash for the purchase. So because they paid cash, there wasn't a mortgage company involved that would have said, wait a minute, this is, there was no questions. So, and no homework done on the permitting side with their former realtor.
So, and correct me if I'm wrong. So the shell was there though, but was it set up as an apartment when the Lewises purchased it?
It was not an apartment. It was an office area attached to a big garage it's really well done. It's all sheetrock. There's concrete floors. It's nicer than the house, actually.
I have a question for the staff. So if there was a garage attached to the principal dwelling, would that square footage be included in the square footage of the dwelling when you do the calculation for how big the ADU can be?
No, sir. So the ADU is based off the principal structure living square footage. So that would not include any covered porches, any decks, any attached garages, any basements. It would just be living square footage of the main home.
Thank you.
You're welcome.
Can I ask a question of staff also? Is it necessary for an ADU that the person who occupies the ADU is the one who suffers from a disability?
No, you do. That would be an ECHO, which is elderly care housing. For an ADU, as long as the property owner lives in one of the units, anyone can live in the other unit. It may be rented. It doesn't have to be rented for a fee. It could be family members. It could be someone they don't even know. There's no qualifications for the person.
Thank you.
You're welcome.
This would not, if the situation presented itself, because of its permanence, it would not qualify as an ECHO unit.
They did not apply for an ECHO unit. They would have to be elderly and they would need to have care from someone else. So that would be a whole separate process to go through. And that also cannot be a stick built. So the goal of an ECHO is to be temporary. And while temporary sometimes can be hopefully for 15, 20 years as we get that person to live with us, it still would be temporary and then would go away. For an ADU, that's permanent and could stay forever. As long as the property owner lives in one of those units, the ADU is there permanently.
Is there a restriction that's meant to be recorded with respect to both an ECHO and an ADU, or just one or the other?
There would be a restriction for the ADU, not for the ECHO. The ECHO would have to be renewed each year with doctor sign-off and age requirements being met. The ADU would have a one-time deed restriction, and that would follow the current property owner and any future property owners.
I apologize if I missed that, but
No, you're fine.
Did the applicant acknowledge that requirement?
They have to get the size worked out, and as long as they can get the size worked out, then to continue through with the process, they would have to agree that they, being the property owners, would have to reside in one of those homes. And then they would have the deed restriction recorded. They would record that. So it would have to be true now. And then when they go to sell the property, it would still have to be true. Hopefully the attorneys and the sellers and all of that will be disclosed to them, and that will be followed through in the future.
Did you understand that, Ms. Wagaman?
Yes, I did.
Pardon me?
Yes,
Yeah.
we're clear on it.
Okay, so that so if you were granted relief from the code tonight, your clients would need to record an easement or a restriction rather on the property to legalize the ADU and use it only as restricted.
And we are so not done. This has been amazing. So I've learned so much. I've learned to not do it again. No, we're very familiar. We're going to follow all the steps.
So this question is for staff. With the ADU being 71.7% of the size of the main dwelling footprint, are you guys considering that a second dwelling, correct?
It very well could be considered a second dwelling. That's why we limit the size of ADUs to be 50%, so that they are not a second dwelling out there. There are many homes in Kent County that are 1,000 square feet or less. So this could be a second dwelling since it's more than that 50%.
I mean, I'm just looking at the staff report. It says something about the code, 205-400.B2.
Right.
So it looks like something we have to grapple with.
And that was another thing that the previous owner developed and just put that building wherever he wanted. So it's been exciting.
So I have a question for staff, just kind of a housekeeping thing, but would the footprint of this house as it is now, if this were just became a part of the house and not something that could be rented out or whatever, would that footprint be legal with all the setbacks and the size for the lot?
So the problem there, Ms. Denny, would be that the ADU is that red there. It is in the detached garage, so it is not attached to the home. The other thing is, this still would be an ADU and would still be limited to the 50% square footage, even if it was attached to the home. The only difference would be the setbacks.
So as we're looking at this, we're at 71.7%. So essentially, that in and of itself would have to be a variance. That is, we'd have to make.
Yes, that's the variance that they are requesting tonight, is to be over the 50% and to go up to the 71.7.
And that would just, with or without you, well, I mean, it's detached from the house, but.
Even if it was attached, they would still be here. If it was the same size, they would still be here in front of us tonight asking for the size variance.
So if I'm understanding this correctly, the magic would be in adding to the principal residence.
Yes, sir.
Or take space from the
Correct.
ADU.
Could they abandon part of the ADU?
They could, sure. Yeah, they would need to remove 322 square feet so that it is not livable space in the ADU. That would be up to the applicants if they can make that work.
They could do so by removing the laundry room, possibly downsizing the bedroom area.
What is the dimensions on that room? Do you know?
Can you show us what you're on the screen next to you? If we were to eliminate, show us if you were to eliminate.
Here, is this showing? Oh, how fun is that? This could be shortened, and this whole area, first of all, the laundry room could be taken away and just the bathroom and shower left. So there would be a big piece gone. This area here, this square. And then the other would be shortening this, which would be easily done, taken away.
Well, doing that would mean that you wouldn't need a variance. I mean, it's an exceptional, that's part of your case, is it not? That removing some portion of this represents an exceptional practical difficulty for your.
It was my understanding that we needed to get a permit for an ADU no matter what. And in this case, we're not only looking for the approval for an ADU, but we would request an exception. So it's kind of two-part.
Another question for staff. If this structure was utilized as an office, other than not getting a building permit, would it be legal?
They would have to go through a home-based business process. So either home occupation or home-based contractor.
Okay, so without doing that, it's not legal.
No, it would not be legal right now.
So it was illegal when it was done, not just because it was done without a permit. It was
Right.
illegal because the use was not legalized by home-based contractors.
So as presented tonight, she is correct. This property was zoned commercially once upon a time. When it was rezoned, they did use it commercially. They did not go through all the steps or all of the approvals. Since then, the use has changed and folks have used it residentially, but they did not rezone it. These folks have come through and they have said, we are using the property residentially. If it's in a residential area, we are going to rezone it to what it is used for. So they have cleaned that portion up to zone it for what it's used for. But, so once upon a time, yes, there could have been an office there and it could have been legal. At this time, if someone were to use this for an office, they would have to go through a process.
And you can appreciate if they are going to sell the property, we want to sell it the way we know it can be used so that we can do everything appropriately, unlike how they ended up buying it.
How long has that ADU been there, usable?
2 years. Which is when they put in the new septic system too, so that everything was done that way, and they did have electrical inspection from the state inspection agency. They just didn't come to you guys.
So all of this was done without a permit from the county to this addition?
That is correct, and that's our
No
next
permitting
step.
from the county.
Yeah, after tonight, I've been well-schooled by planning and zoning and by the inspections department, and I've met everybody, so my next step, this is my third step, my next step is permitting.
But it wasn't an addition, it was the building prior to this applicant built the building without a permit.
Yes.
And then they came in and just fit out this portion for the ADU without a permit as well. But it wasn't these guys didn't the applicant did not build an addition off the garage.
It was existing, but when they went to settlement, I guess somehow when they settled on this new property, it was the footprint having grown kind of got missed along the line.
It wasn't
And
mentioned
so
by
was
their
there-
lawyer. If he looked at the survey, it definitely was not investigated by their realtor at any level, because it's clear if you go into the county records, you see right away that there's nothing. I mean, nothing.
Did you say there was a survey at the time of the closing?
I'm not familiar if there was.
You
but
said it was a cash deal.
it was a cash deal,
So
so they may not have opted for a survey because of that. It was very difficult to explain to them what they had done. They were extremely embarrassed and just trying to straighten things out.
Can you touch base on the financial impact that this will cause if you have to get it down to this 50% to reduce this ADU down to the 741 square feet? Can you just touch base on the financial impact?
If we are allowed the ADU at a reduced square footage, that will not highly impact the value at all.
And in your opinion, the cost would be relatively minimal to do that?
The gentleman does a lot of his work himself. Matter of fact, he came in to even make sure, because we know now we have to have the fire marshal come. We've got a lot of homework still to do. And he's already established the right windows, the right doors. I mean, so no, he could handle it with a permit.
So what's the percentage to not have to deal with the 205, 400? Anything over 50% is considered?
Right, so that is the question here. If it's over 50%, then it doesn't meet the ADU. We don't have a specific amount for this is a second dwelling. That's where we caution you that if you approve so much more than 50%, you could be looking at 2 dwellings out there. And that is prohibited by the code.
And how do we stop that, like consider 2 dwellings? Is it the paperwork of the ADU?
Denied the ADU. I know, I'm sorry.
But the 50% is based on the size of the primary dwelling. So, I mean, this size dwelling might be permissible if you had a home that was larger than this one by not a great deal.
Sure.
So you have to take into consideration the size of the primary dwelling when you determine how far out of compliance this project is.
So if we were to deny the ADU, and then this is just a single-family dwelling, is that?
So if you denied it, these folks would have a couple options. They could remove 322 square feet of the accessory dwelling unit. They could add on 644 square feet to the principal dwelling unit, or they could remove the ability for this to be a separate living unit altogether. So remove the ADU altogether. That's, again, all options if you deny the ADU.
Yeah, I think the easiest option is to reduce the existing ADU, cutting that square footage down.
By 21.7.
Any other questions? All right, I think we're good. Thank you.
Thank you very much.
Thank you. Is there anyone else that would like to speak on application, in favor of application A-25-33?
If there's anyone joining us online that would like to speak in favor of this application, please indicate by raising an electronic hand. No hands raised online.
Thank you, sir. Is there anyone that would like to speak in opposition of application A-25-33? Again, if you are online, please raise your digital hand.
Still no hands raised online.
Thank you. Seeing no one, we will close the public hearing for application A-25-33. Next up, we have application A-25-34 for South Bowers Fire Company. They are presently zoned AR. The variance is from the required 15-foot parking setback from any residential property line to legalize existing parking. The present use is a fire department. Proposed use is same. The Levy Court District is 4th for Mr. Scott, located on the northeast corner of Bennett's Pier Road and Scott's Corner Road, east of Frederica. Here you will see the subject proper, or the parking, 3 feet 3 inches from the side property line. The required side setback for parking would be 15 feet. They were granted a site plan to allow them to go 10 feet from that side property line back in 2009. This is what was proposed and approved back in 2009. And you'll see that 10 feet from the side property line. This is looking at the existing fire department building. Down towards the corner. Down along the parking and the side road. In front of the fire company. This is the area of the parking in question. That's 3 feet 3 inches from the side property line. Looking down that side property line. Again at it. And the aerial. So if one of you folks would like to come forward, state your name and address, and allow our attorney to swear you in.
Yes, my name is Jack Potter. I live at 38 Valley Forge Drive, Melford, Delaware.
Mr. Potter, Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Okay. I am, at the present time, I'm chairman of the board of directors for the South Powers Fire Company. I've got 68 years with the company right now. This is my first time I've had to appear before you folks, so just bear with me. This is all new to me. Okay. So, that being said, we are looking for a 3-foot variance. Our big thing is we're trying to erect a sign out in the front, which I can't show you on that, but anyhow, up in the front of the building, we want to put a new sign up there. Our old sign's kind of obsolete. And this sign that we want to erect is something that we depend on to get the word out to the community in order for fundraisers, functions. In order to do that, like I say, we need to get that 3-foot variance. I was told I could not put that sign up in the front because I have to get the variance in the back before I can do that. So, is there any questions?
Thank you. Any questions for Mr. Potter?
I just have one. So when we're looking at page 20, can you put page 29 up?
Sorry, I'm not sure which one you're referring
The
to.
one that shows the sign that the,
What she just showed, that pickup's where that sign's gonna go.
yeah, but you know, there's a picture,
Right there, yeah.
right?
Just to the right of that
Yeah, well,
pickup is,
there's one that actually shows the sign, the existing sign,
oh, the old sign, I'm sorry.
the old sign.
Yeah, it's
Yes.
right behind that pickup, yeah, yeah.
Okay, so, that sign is the one you want to enlarge, is that?
No, ma'am.
No, no,
No,
okay.
ma'am, we want to completely remove that sign, and where you see that white pickup there, we want to move the electronic sign up in there. It's a more modern sign. This is one of those signs where you have to put the letters on, take the letters off. It's kind of outgrown its time, and the ladies, you know, they're out there in the rain trying to change the sign. It's not a good thing. So we're trying to get this electronic sign, and we want to put it up close to the road where it can be seen. As you can see, we have a road that runs all the way around the building. So if we get this sign up there, electronic sign, the public will be able to see it. And it's important to us for the simple fact that we have a lot of fundraisers with the fire company. We're located in the country. We don't have a town, per se, to help us out with this kind of thing. So we depend on the people in that area for the fundraisers to raise money to keep the fire company going.
So this sign is what triggered the parking, is what we're asked to do tonight, look at that. So touch base on this parking. How long has it been there?
I'm sorry?
The parking spaces?
How long has it been there?
Yeah,
For approximately 10 years.
10 years?
Yes. Yeah, they told me that in order to put that sign up, if I don't get this variance, that I have to tear up 75 foot of that parking lot, and that's 3 foot, you understand, in, and 75 foot out, in order to get that sign put up. And I tell you, we need that parking spot bad.
Do you lose the parking if you remove that portion of the?
Yes, sir. We lose a lot of it. Yes, sir.
And what's the neighboring property?
I'm sorry?
The neighboring property, looks like it's a wooded property, correct?
That neighboring property, yes, it belongs to the Webb family, which is agricultural over there. Yeah,
And behind you, behind and alongside, some of that is wooded and wetlands, that's the
Yes.
soils.
Yes,
Yeah,
ma'am.
that's
yes, ma'am.
what
Yeah.
I kind of had remembered. Okay.
See, this whole thing began, I don't want to take up a lot of your time, but I'll go through this real quick. I went up to the planning and zoning and I asked to get permission to put this sign up. The first thing they told me was, you can't do that until you register a deed. A portion of that property, you haven't registered the deed. So, and that would be the far corner on the right-hand side of the property, a real small piece of it. So I went back and I got to looking, come to find out we don't own that property. So I come back up here and I talked to the lady. I said, look, I can't register a deed to something I don't own. So I said, where do we go from here? Well, she said, you're gonna have to have it surveyed, showing that you don't own that piece of property. So I said, if I do that, I can put my sign up. And she said, yes. I said, okay. So I spent $3,000 to have it surveyed. Guess what? I opened up a can of worms. Now she calls me and says, look, you can't put your sign up because you're over 3 feet on the parking lot. So here we go.
I apologize, I don't think it's funny. It's
That's
just
okay.
like,
Yeah, it's
I just want to know who's on first.
I'm gonna tell you something. I'm 84 years old. I want to tell you, I think I got a lot of patience, but I'm starting to run out.
So this question is for the staff. So when is this survey on item number 32? When was that submitted and approved?
You had a picture of it up there, I think, where it was surveyed when you showed the
Are you talking, sorry, Mr.
I'm sorry, the question was for the staff.
Okay, so if you're referring to this one here that has the orange color on it, that was approved back in 2009, and that allowed them to have this parking to go 10 feet from the side property line. They had it back then on the site plan to be proposed hot mix. We allowed it, so we would uphold the 10. Since they are coming forward to us now, and we are noticing that it does not meet 10 and it does not meet the current code of 15, that is why they are in front of you to ask for the variance. If they were at 10, this would not be a discussion tonight since it was an approved site plan.
10 was approved back in 2009.
Yes, sir.
And the normal setback at that time was 15?
I believe it was actually even greater than that, but the site plan was approved by Kent County Planning. We will uphold that. We will uphold the 10.
So why is it, if that was approved at 10 feet, then are those not legal parking spaces that were approved? Because are they too short?
Up to 10 feet they would be, but they are now 3 feet, 3 inches from the property line.
But why is it that removing the 3 feet would eliminate all those parking spaces?
So they would actually be looking at about 6 feet, 9 inches to be removed, and they wouldn't meet the parking size requirement for each stall, parking stall. Did I answer that correctly?
Oh, it's not 3 feet that they would lose, it's...
Correct. Yeah, they are currently 3 feet, 3 inches from the side property line. So to meet the 10, they would be looking at removing 6.5 feet-ish.
Okay, I didn't understand that.
Yeah.
All right, thank you.
Mm-hmm.
Okay, so for discussion, this has been in existence for how many years?
But the
10
parking lot
years.
itself, approximately 10 years, ma'am.
10 years.
Wouldn't it be 18 years? 2009?
2009 is when it was established, so 18 years?
Okay.
Okay.
Yeah.
So it's been like this for 18 years. And just legalizing it with the survey, certainly, which was necessary, and I'm not objecting to the fact that you had to do it, but that, I'm sure, was a huge practical difficulty to a fire department and a volunteer fire department. So, and so all you need to do, all you want to do now is for this board to legalize what you have. You don't want to expand it. You're not going to try and make it bigger. And then he'd be able to put the sign as well. He'd be able to get a permit for the sign.
They are working with another one of our planners to move forward on the other necessary items that may be required, and that was a discussion with this, I believe, this gentleman and another planner in our office. So they would have to finish those steps, and I apologize. I don't know what you and Jesse had discussed on what else would need to be done, but that would legalize this portion and allow them to continue forward.
So this is like step one of the process, is legalize this.
Yes, ma'am.
Okay.
And the next step very well may be pulling the permit for the sign, but I don't know that exact conversation that
Thank you.
they and Jesse
Thank
have.
you.
Excuse me. Jessie told me that if I get the variance, my next step would be to have the surveyor file his paperwork with your department.
Okay, so then I would assume that would be an administrative site plan update you may
Yes.
have to do. Yes.
Exactly, yeah.
Yep.
Any additional questions for Mr. Potter? Seeing none. Appreciate it.
Thank you.
Thank you.
Appreciate your time.
Is there anyone else that would like to speak in favor of application A-25-34?
If there's anyone joining us online that would like to speak in favor of application A2534, please indicate by raising your electronic hand. No hands raised online.
Thank you. Is there anyone that would like to speak in opposition of application A-25-34? Again, if you are online, please raise your digital hand.
Still no hands raised online.
Thank you, sir. Seeing no one, we will close the public hearing for application A-2534 for South Bowers Fire Company.
Thank you. With that, the public hearing is now closed. Does anyone need a break or keep rolling? Keep rolling. All right, I like it. All right, we'll begin the business meeting. Do roll call, please, for
Yes, sir. Mr. Carter?
Here.
Mr. Gallo?
Here.
Thank you. Ms. Denny?
Here.
Thank you. Mr. Jenkins?
Here.
Thank you. Ms. Hudson?
Here.
Thank you. And Mr. Cusick?
here.
Thank you. That's 6 still present.
Thank you. Begin with the business meeting minutes approval. We need approval for the November 20th, 2025 meeting minutes.
Joan Denny, I'll make a motion to approve the minutes from the November meeting.
Second.
Got a motion and a second. All in favor? Aye.
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 Notice of decisions from the November 20th, 2025 meeting. We have application A25-31 and application A25-30.
I make a motion, we approve the notice of decisions of A25-30, 31 as presented.
I'll second that motion.
Got a motion and a second. All in favor? Aye.
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 Thank you. And now we'll begin the new business deliberation.
Yes, sir. So first up, we have application A2533 for Amy and George Lewis. Again, they are seeking a variance from the maximum ADU size of 50% of the principal dwelling. Principal dwelling is 1,482 square feet. Permitted ADU of 50% would be 741 square feet. And the existing ADU there, they are looking at legalizing is 1,063 square feet, which would be 71.7%.
Thank you. Discussion. Yes, sir. It's just unfortunate at this point, so much has been done that that didn't involve permits. I can appreciate the testimony given by the realtor sharing with us their efforts to make corrections and improvements. I can recognize and appreciate that.
Well, I appreciate all they're going through to rectify, but I really think, I think that it needs to come down in size. And again, a lot happened here, you know, something may have gotten missed by council or realtor or something, and the settlement, whatever happened. But ignorance is not an excuse. So I think my feelings are it has to come down some. I mean, it can't be, to me, 71.7% is a huge amount.
It looks like from the floor plan, the pieces that stick out the back, if you take those off, it reduces it about 180 square feet which gets us somewhere around 59 or 60%.
Is that office counted in that square footage, Jamie?
No, sir, it's not. It's just the laundry room and then the orange on this floor plan. So the office, and there's like maybe a little entryway here, that is not counted as part of the ADU.
So all we're looking at that would need to be reduced is in the addition, the 10-foot 8x7.7, if that were cut down. Is that,
No, ma'am. I mean, rough math, that would be 80 square feet. And that is the laundry room. So that is something that Ms. Bigenman, sorry if I pronounced that wrong. Okay. She stated that would possibly, the applicants would be willing to remove that and some of this along here. But that laundry room would be roughly 80 square feet.
I guess if I'm looking at this right, if you added on, if they were able to add on 600 feet, that now takes the house over 2,000 square feet. And in order for the ADU to qualify at 50%, that would put it at 1,000 feet.
I just think it's much easier to reduce. I think I'm not sure what the square footage is, like taking the laundry room, pretty much what the applicant said, taking the laundry room and then maybe along that wall, where the closet bedroom is.
Yeah.
on the
Bottom right corner, yeah.
A bedroom.
Just going straight up, so up against where the 20-foot 3 dimension is, taking 3 feet off of that whole side, because that's an exterior wall there. Exterior wall down at the bottom. So it's really just building, making that bedroom smaller. They already have a closet in that bedroom. So
I think that's the only window on that side, though.
now there's a window at the bottom. Yep. I mean, I think that's the easiest, just building the wall straight down off that closet, and eliminate that laundry room. And what's that square foot? So it's 20 by 4, and then 10 by 7.
I think too, in the testimony, part of the discussion was that I think the owner is pretty handy, I guess, with carpentry skills or having the ability to do this. That's kind of why I just threw out there about the addition.
So, Mr. Cusick, where would that put us square footage-wise?
Like 150 square feet. I mean, I just think just the unusual, unique circumstance that created here.
You mean would not using permits or?
Just everything, not.
They did invest money in hooking up that septic as well.
Well,
What'd you say, Mr. Gallo? I missed that.
They also invested money as far as the septic and connecting that ADU. I kind of go with Brian's idea as far as the minimum amount to give them relief.
I think allow 900 square feet. That's 160 square foot over.
So I'd say this, that if you're inclined to grant some relief but not all of it, then it's probably not up to the board to design it, but to determine, I mean, I think it's important to understand the existing design in order to determine how much relief makes sense. But
Yeah, it'll be up to the applicant to get it down to that 900 square
Right,
feet, whatever
and-
way.
so I think you have to do your best, maybe with staff's help, to figure out how much relief seems to accomplish what you think makes sense, but in the end, it's up to the applicant to make use of the space
Yep.
and the relief that you give them.
Yeah, agree.
So we could bring it down to,
Then we'll have that
If
percentage.
you reduce it to 180 square feet, you get down to about 60%.
Just to throw more numbers in there. If you remove the 150% that Mr. Cusick, or I'm sorry, 150 square feet, Mr. Cusick had mentioned, that brings you down, excuse me, 913 square feet, and that would be 61.6%.
So if that's what your motion might be, no matter what your motion is, I would ask that you
Yeah, I
round it
would
up a little and give everyone some flexibility, including staff, to approve something that,
so as an example, if we just said, bring it down to 60%, and then they will make their own design and decide what they can live with and what they can live without and where they're going to take it from. Is that?
so was the calculation 62 that was done? 67. Okay. And your motion is or you're inclined to vote in favor of a motion to reduce it to 60?
I was going to
Yeah,
say.
I think 60 is probably appropriate. I mean, I think I rounded down on my numbers too, so.
Okay, so I was going to say come down to 60%, but whatever. I mean, I'm not going to fight over.
60% would limit them to 889 square feet.
I think that's reasonable, you know, and then, and again, I wholeheartedly agree, let them figure it out. Is somebody okay with that enough to may have a motion or what? Okay, so I will make a motion that that the square footage be reduced to 60%, and the property owner can make the decision as to how they will get to that figure.
Second.
Thank you. Ms. Denny, may I have your reasonings?
My reasoning is that we're meeting them, as far as I'm concerned, practically halfway. To be honest with you, if we would choose, if we needed to, we could ask them to eliminate the addition completely, and just come bring it down to code. So I think we're kind of meeting them to a certain extent by helping with that. It's hard. I mean, I suppose there is some amount of exceptional practical difficulty here. Well, number one, I guess they purchased this not realizing that was a problem. But I don't feel as though we can adequately do our job if when something like this comes in, we just say, oh, okay, well, they didn't know. And I suppose if they really, you know, at some point, they didn't hire the attorney or the surveyor or any of those things that were supposed to be done. These are new owners. You know, so to me, it should have been picked up somewhere prior to settlement, and it didn't happen. But in the meantime, the county shouldn't have to pay the price for that. So I think we should meet them at 60%.
Thank you. Mr. Gallo?
I'll vote in favor of the motion. I believe the applicant's representative testified that they would be able to make some changes to meet us halfway. So we're giving them the minimal amount necessary for them to move forward with this ADU. They do have quite a bit invested in the property, and the property existed as a shell prior to them owning it.
Thank you. Mr. Jenkins?
I vote in support of the motion for application A25-33 for a couple of reasons. One, based on testimony that was given to us this evening in terms of making improvements and corrections on past failures, lack of permits, and just the fact that we are in a process of trying to compromise with the homeowners on the encroachment that exists with the code. We're giving up, I guess, 10%, and they're getting 10%.
Thank you. Ms. Hudson?
I'm going to vote in favor of the motion. Based off the public testimony that we heard tonight, I believe this is a unique situation. There is a financial hardship on the applicant, and I believe removing the restriction does not seriously affect neighboring properties.
Thank you. Mr. Carter?
I vote in favor of the motion based on all the discussion and testimony tonight.
Thank you. Ms. Denny?
I'm going to vote yes for the reasons stated as I made the motion.
Thank you, ma'am. Mr. Cusick?
I vote in favor of the motion. I think per the testimony given tonight and then the neighboring property letter of note that it's not impacting that property with an ADU on this property. Just the unique characteristics of this property all come in play here with the rezoning that had to happen and the existing building. And I think, again, per the testimony, just with the applicant willing to meet us halfway here, I think all in favor. Thank you.
Thank you. That's 6 in favor of the motion.
With 6 in favor, modified approval for application A25-33 to allow 60% ADU of the 60% of the floor area for the main dwelling unit for ADU.
Thank you, sir. So next up, we have application A2534 for the South Bowers Fire Company. Again, they are looking at a variance from the required 15-foot parking setback to be 3 foot 3 inches.
Any comments? Motion?
Well, I'm going to make a comment. I think this is an all-volunteer fire company, and anytime there's something going on in the community, and I'm talking about probably the whole state of Delaware, but I definitely know in Kent County, and you call upon them to bring out their trucks and their men and participate in a parade or do anything to help the community, they are there. And I think when you look at the property and what's located behind it and alongside of it, and it's interesting because when I first opened and saw the Bowers, I thought, gee, I always thought everything in Bowers was underwater because sometimes it is. And I think I certainly would not want to make this a normal thing, but in order for them to do the fundraising they need to do to keep their equipment, their gear, and all of those other things, they need to be able to hold functions, fundraising dinners and fairs and whatever. And I think they need that, if they need that extra amount of parking and the neighbors don't object, the neighboring property, I can't imagine Webb would anyway, but I think that I think they should have it.
When you discussed the parking that's in question, was there a wooded buffer separating it?
It's both wooded area and I'm sure it's wetlands because it's so, yeah, because that's what Bowers is. It's a wetland with a couple of dry spaces with buildings on it.
Well, any more questions or anything? I'll make a motion for A 2534 to pass the variance of 12 feet to allow parking 3 feet from a residential property line. I believe removing the variance does not change the nature or the characteristics of the surrounding area. It does not seriously negatively impact neighboring properties, and based off the public testimony that we heard tonight.
Second.
Thank you.
All right, motion and second.
Thank you. Mr. Gallo?
I'm going to vote no on the motion. There was a variance from the original setback requirements that was in the plot plan in 2009, and it was either disregarded or ignored. The time to discuss those parking spots at that time was then, at that time, so I'm going to vote no.
Thank you. Mr. Jenkins?
I vote yes in support of the motion for application A 25-34, primarily because of the testimony before us this evening and the fact that the parking lot that's in question has a wooded buffer that, and it's been there since 2009, 16 years. So,
Thank you. Ms. Denny?
I vote yes. I think it is necessary to support the function of this volunteer fire department. And I do not believe that it will have any effect on the neighboring properties whatsoever. And we have no objections. And it was posted like everything else is. So, yes.
Thank you, ma'am. Mr. Carter?
I vote yes on the motion based on the testimony tonight and the fact that it's been in existence for 16 years without a problem, so.
Thank you. Ms. Hudson?
I vote in favor per my motion.
Thank you. And Mr. Cusick?
I vote in favor of the motion. No impact on neighboring properties. It's existing parking lot's been there for 16, 18 years, so it's been there for a while. That has had no impact on anyone that has been brought to our attention, and then obviously the hardship is there now to be able to have this owner make normal improvements to the property, much needed improvement on the property for this, allowing them to the sign.
Thank you. That's 5 in favor of the motion, 1 opposed.
With 5 in favor, application A 25-34 is approved.
Thank you.
I'll make a motion to adjourn.
Second.
Motion and second adjourn. All in favor?
aye.
Eh.
My pen's in there. Okay.
Thank you so very much. Everyone have a great holiday. Really grateful. Thank you.
I'd also like to thank everybody for their time and have a Merry Christmas.